Now, this is Diesel We the People News. I'm not an attorney, nor care to be an attorney. Everything it says or does is my opinion, and this is a learning video. Always look around me. I don't never look straight forward because I want to be able to protect myself by any means necessary. So, this one's going to be a few parts video, mainly because it's very important to listen to these people talk because they're in the battle. Okay, and what I like about this man Bill, okay, he's just heading it straight on. All right, he's using every single Constitution, court case, and all that against the courts. And I will say that I used his documents on a case of mine, but I infused it with some of mine. And so far, it seems to be working out pretty good. Okay. My case would probably never be settled. It probably can't be settled because if it ever gets settled, then it's going to be in the court's records and they can't have it. Okay. You guys already know on some of this stuff, and this man Bill, he understands what's all going on. But again, instead of playing chess games with them on some of the ways these other people are doing it, he's going after the button them with he's doing a headbutt with them. Okay, he's just coming straight after them. He's not playing guess. He's not playing chess or nothing. He's just directly going after them. I'm hoping I will be able to talk to him sometime tomorrow because I want to talk to him. But let's see what they have to say. And again, this is going to be probably 3 or 4 videos because this is a long video. But it's good to hear what they have to say for people that's actually using it and dealing with the courts system and what is good and what is bad. And what do we need to do?
Hi, my name's Adam, and I'm here with my very dear friend Bill, and we're making this video to share about a case that we just submitted to the U.S. Supreme Court. Actually, it was in about mid-September, and to give you all an update about it. So if you want to read the suit, it's against 16 state and federal judges. You can find it at www.thespiritoflaw.com. And you can check out all of the supporting exhibits and the procedural history. They're all there that you can either download, print it, or view it online. So at this stage of the game, I'll share more about it in a little bit. But the court has rejected the filing of it based upon procedural rules. So with that, I'll hand it over to Bill, and he can talk a little bit about the court's history of doing that and the treason that's involved in it.
Well, they have quite a history in that area, especially the last 160 years for not doing their job to say what the law is, Marbury versus Madison, for those of you that don't know. And in this case, Adam done the best pleading I have seen, and I've seen some good ones, but this, and he does it, he's much nicer than I am. He uses their forms and tries to get it done in ways they'll recognize it. I go in there a lot more with attitude and authority and say this is the way it is because we created this whole thing. We own it. This is principal and agent. And yet what's happened to him, I still shaking my head. The justices haven't even seen the petition. And this is where you get, and by the way, if you get on my website, uwinthecourt@gmail.com, I'll send you information. One of the things you get are quotes from a case called Cohen's v. Virginia, 264, 1818. Oh, that's old law. They don't use that anymore. Well, the Supreme Court used it twice in the last term in cases involving the state of Texas where they refused to file documents. We're not going to get into that. But what's relevant here with Adams' case is, let me give you a virtually verbatim quote from Cohen's. And this is Chief Justice John Marshall saying it. Their ultimate icon, was never wrong, right? At Cohen's, the Constitution gave to every person a right to present his case to the court of the nation. No matter how small the claim, nor how little interest the community in its outcome, the framers of our Constitution thought it necessary for the purposes of justice to create a tribunal as superior to influence as possible, in which that claim might be decided, unquote. And we can't even get documents filed in trial courts now, and Adams' petition doesn't go to the justices of the U.S. Supreme Court. You figure it out. Take it from there for a bit, Adam. Go ahead.
Okay, yeah. So I did send it to the Supreme Court, and I sent 10 copies as was required by their rules, and a majority of the petition is in the format of their rules. But if you go to thespiritoflaw.com and you scroll down on the homepage, there's an update from September 28th, 21, and you can download the clerk rejected filing it because it wasn't in the form of the procedural rules that they said that the Supreme Court's rules, in other words. So what they've done now is they've used procedural rules that they created to deny rights secured by the Constitution. So let me give you just a little bit more context about how that's working. So there's the federal rules of civil procedure are what supposed lower inferior courts of the United States use as their procedural rules. And Rule 5 says, the clerk must not refuse to file a paper solely because it is not in the form prescribed by these rules or by a local rule or practice. Now, comparing that to the Supreme Court's rules, the very first rule, it says the clerk receives documents for filing with the court and has authority to reject any submitted filing that does not comply with these rules. Now, let me give you some more context with that. This is from a case of Miranda v. Arizona. It says, where rights secured by the Constitution are involved, there can be no rulemaking or legislation that would abrogate them. In other words, they can't make procedural rules saying that you didn't put it on the right size paper or you didn't use the right size font and then deny all of your constitutional rights, because that would in effect be overruling or superseding the Constitution. And so there's other cases. One's Nashville v. Wallace, and that says the Constitution does not require that the case or controversy should be presented by traditional forms of procedure, invoking only traditional remedies. The Judiciary Clause of the Constitution defined and limited judicial power, not the particular method by which that power might be invoked. So to kind of summarize all of this is that there seems to be rules for the lower federal courts, but not the Supreme Court. And the Supreme Court can make rules that can overrule or supersede your rights to the Constitution. And these rules haven't ever been to my knowledge, they've never been submitted to Congress. They've never been submitted to the president, or even the public was not even allowed to comment on them. So, as Bill had mentioned one time, the Supreme Court's not a legislative tribunal. So, anyways, that's where we're at. Oh, there's one other thing. I did send a letter to Justice Clarence Thomas, and you can also find that on the homepage of the Spirit of Law website. And I believe it's as of, let me just see, that was sent on September 29th. So we're going on 2 weeks now, this Friday, I believe it will be. So with that, I also want to welcome my other dear friend, Georgette, who is here to be in support.
Welcome.
Hi, Bill. Nice to see you too.
Nice to see you too.
Have you guys met yet?
Not formally, no, but we talked on the phone rather a bit with you. So yeah, we have. So you're a couple of cooks there, Georgette. Look out, we're real troublemakers.
There's nothing I love more.
She's going through her own legal stuff. We can talk about in a little bit. But Georgette, did you have anything? I know you kind of jumped in right while I was, kind of giving a little bit of a background, but you know what's going on. And is there anything that you'd like to share from your perspective?
I don't think so. Not at this point. But I'll let you know as we go along. Okay. And
Okay.
I may have to leave. How long do you expect we'll be on here?
20 minutes, 30 minutes,
Oh.
maybe.
No, never mind. I'll be here.
Okay.
Okay.
So, Bill, your turn, if you will.
Okay, well, some other issues come into play here, and what Adam put in can and should have been construed as a non-statutory federal writ of habeas corpus pursuant to Article 1, Section 9, Clause 2 of the Constitution, which can only be suspended during declared cases of rebellion or invasion, not COVID pandemic. And in effect, these rules, if applied here, would allow the clerk of court to effectively do that. And again, Collins v. Virginia, the court has said in there, once again, that to refuse to take jurisdiction when you have it or to exercise it when you don't, the one or the other is treason to the Constitution. That's exactly what apparently is happening here. And like Adam, I sent a cover letter to Justice Alito. These are the two that wrote the dissenting opinion, quote unquote, in the case of Texas v. California, and cited Collins, and they did it in an earlier Texas case. And you can't cite that case unless you know what it means. Most of its dicta is not relevant to the decision. It was quite a case in its day. But you have to understand, listeners out there, we have better standing than the states we created. It's a principal and agent relationship. And if they're saying on the one hand that Texas can't file there, and that's the only jurisdiction they have, Article 3, Section 2, in all cases, ALL, in which the state shall be a party, the Supreme Court has original jurisdiction. The mainstream media caught on to this, but they either missed it or were misled, I don't know which, by 5 words. Cases in which a state, and the central issue that I have of all the unopposed issues I advocate, there are no states, and that affects a lot of what Adam's doing in his case too, because if we don't have any states and no judicial courts, whatever laws they use, in his case it was Business and Professions Code, null and void, non-pro-tunc, ab initio as a bill of attainder, Article 1, Section 9 or 10 as the case may be. And wouldn't you know what I said about the court not having done its job? The last time they seriously ruled on this issue, Cummings v. Missouri in 1867. That's not coincidental. We start making issues like this and get away from this civil rights crap, all of us are going to do a whole lot better and quicker. And I think the court, if I'm reading the tea leaves right, and I've been doing that for 5 decades, this term may actually be seriously considering it, because what I just said with Alito and Thomas, I think they were joined by the 3 Trump appointees at least, who were told for the moment, for whatever reason, to stand down. Right issue, wrong time. We'll see with them back in session. Are they going to understand some of the points I just said and what Adam put in his material too? If that happens, we are in for a lot of good times here, notwithstanding whether Biden attempts to pack the court, quote unquote. Especially interesting if he tries to do it as commander-in-chief, which really tells you, and that's why I think the court has their backs up, because if he can do that, he's saying to the Supreme Court, not only you're not a judicial court, there are no judicial courts. That's the only one created by the Constitution, and they're saying, without overtly saying it, that the Constitution has been suspended. And I don't think that's happened. So that said, let me get back to Adam for some more commentary.
Well, that was one thing that I wanted to explore with you both, was the fact that because they refused to file my petition and exercise jurisdiction where the Constitution gives it, where are we at right now? I mean, is that not a tacit admission that there is no Constitution and we don't have a right to a judicial determination of our rights there? I mean, it is, but at what point, do I say, well, they're not going to hear us? I mean, I have a couple of options. meaning I could put it on their forms, so to speak, or not their forms, but format it in the way that they want it to be, which would actually, I think, based upon what I filed, be 2 or 3 different separate filings. First, because they said if it's the non-statutory writ of habeas corpus, it has to conform to that filing, and you cannot combine that with any other filings. Well, mine was essentially combined with a writ of error, and then they said to that there is no writ of error recognized by the rules. So where that went, I have no idea, because it's a court of law, and the writ of error comes up under the court of law, of common law. And then the other one is essentially a suit against all of the 16 state and federal judges. So getting back to my options essentially are, if Thomas doesn't respond and say that we can file the case, well, then either I go to that route or I stop moving forward in that court and file bankruptcy, unless there's some other option that comes to mind, or I don't know. Do either of you have any other ideas? Or
Well, I would say that there's usually more than 2 options. Even if we don't see them right now, again, this is intuitive. I don't get that you either have to file bankruptcy or file several different, what do you call it, petitions or suits.
Right.
That there's something in between there that just hasn't been seen yet. I'm not sure what it is.
Me neither. And yeah, there's definitely options in that regard. Those are 2 of them. Another one is to let the house here, it's my mom's house, go into foreclosure and see what happens in that process. Mm-hmm. But all of these, well, the latter 2 seem to all be a result of the court not being willing to accept the filing, which is so, I mean, as we've been talking, if you strictly construe the Constitution, well, not even strictly construe it, it's just what it says. When they have authority to do something and they have a duty to do it and they don't do it, that's treason. So they're not doing it. And, as far as the letter that Bill and I wrote to Thomas and Alito, what do they have to do but write back and say, file the case as it is and be done with it? I mean, it's not like they have to review it to see if it's worthy of their time and effort. Although maybe they would do that. I don't know. But
I was listening to someone, I don't remember who it was, and they were having a similar problem in having the clerk of court file their papers. And they put the clerk of court on notice, saying they were going to sue the clerk of court if the clerk didn't file those papers, and the clerk did after that.
Well, that brings up another piece of this, is that after the Supreme Court clerk refused to file my papers that I submitted, I went to the district court in California, the federal district court, and I sued the clerk of the United States Supreme Court in that court for refusing to file the documents and exercising the judicial power of the United States, which he has no authority to do, to deny my petition or my filings, whatever you want to call them. And within a few hours of filing suit, I got an email from the judge who it was assigned to, and he essentially threw it out as frivolous.
Oh, I remember now, yeah.
Yeah, he said, this court doesn't have any power to tell the Supreme Court what to do. And I promptly wrote back an amended complaint to him and said, au contraire, it is your duty, if rights are being violated by the Constitution, it doesn't matter who, whether by the Supreme Court or anyone else, you have a duty to protect those rights. And he basically said, bye-bye.
Is there any other way you could sue the clerk of court?
Well, I suppose I could bring another suit in the district court for the District of Columbia, but I'm not sure how that would go, given the fact that the district court here already ruled on that issue, even though it was the wrong venue. I don't know, Bill, what do you think about any of that, or do you have any thoughts?
Well, yeah, there's a lot that goes in, Adam. I was thinking as you were talking, and the DC is attractive. I'm still researching that. I will get back to you. But as you know, I've recently come into, and with their help, by the way, the California District Court, which is there pursuant to the original Constitution of 1849, which the Secretary of State says here, pursuant to your request for documents, there's no record of it having been repealed. Contemporaneously recognized as a constitutional common law court, it would also then have concurrent federal jurisdiction of an Article III circuit court. And we don't have any state bar member attorneys that are qualified to be judges in that court. That's our court. They can't even come in there unless we let them. And they can't compel us into their jurisdiction either, which in effect the framers of the Constitution identified for what it was: jurisdiction foreign to our Constitution and unacknowledged by our laws, admiralty and maritime. And just to note here, as Adam knows, I never got my document filed either, but when I was alone in that South Carolina jail cell 5 years ago, I did up an 18-page hand-printed writ of habeas corpus. And you can see I'm sitting here talking to you today because they got that, and I'm sure they got a call in Columbia. Get him the hell out of there, because we can't answer these issues, any more than what they may think now, although that's a big change we may see, and it may come in Adam's case. Because 5 years ago, it was clear that I made good points. I had 40 case citations in there, no errors. And here I am sitting here, and they wanted to go after me because I was challenging the South Carolina bar in that case. And they wanted to put me away as long as they could. And here I am. They didn't come close. If I had a video of the first meeting I had after being dragged across the country 2 months, shut them up in 30 seconds flat. That's what you learn to do when you study like I have, and what I can teach you to learn how to do. And you go in there, and I'm the one there manacled hand and foot in a red jail suit. They're the ones in trouble with the law, and everybody knew it. That's power, people. That's what the framers put in our hands. That's what we want to get back, whatever it takes to do it. By the way, another case of this type, not nearly as good as mine, Clarence Earl Gideon v. Louis L. Wainwright, 372 U.S. 335. And Gideon was forced, because he wouldn't give him anything to write on when he was in that Florida jail, to write it on toilet paper. The Supreme Court took the case, heard the case, decided it, and set him free. It's not my favorite decisions for reasons we won't discuss now, but on toilet paper. And Adam's case can't get seen by the justices, let alone heard and decided? What the hell are we doing these days? And this is apparently the only court, unless behind the scenes they know exactly what I do about the California District Court. If that's our constitutional common law court, that's the jurisdiction and venue. All we need to do, and by the way, the county clerk is identified as the ex officio clerk of that court, Article 6, Section 10 of the Constitution, 1849. And like Adam correctly and brilliantly points out, the Constitution of 1879, as amended, doesn't vest in judicial power of California anywhere. And it doesn't need to, because the body politic that represents isn't the body politic of the Constitution of 1849. Completely different. They all owe their citizenship, such as it is, to Article 1 of the non-existent 14th War Amendment. And you'll learn, send me an email, uwinnincourt@gmail.com. You're going to learn that amendment doesn't exist, and it never has existed, and that's all they have. That's how we're going to beat them one way or the other and put them out of commission. It's simply not there. It never has been. But they didn't tell me, and like you, I didn't learn a damn thing in school 50 years ago, and I wish I would have, right outside of Washington, D.C., when, life would have been different. But better late than never. But they don't teach you, so you don't have any way to know. Attorneys are not going to help you. The only one I've seen was from Minnesota. I'll think of his name here in a minute. That would have even thought to have done that. Nowadays, they're all in the game. They're unregistered foreign agents, maybe agents of the City of London, with the sworn oath to that organization that the one they take to our Constitution. So these are the things that have to change. Once we understand the perspective and the situation we're in as principals and agents, it gets a whole lot clearer in a hurry. And by the way, I was at the head of the list of being ignorant, to the point when I was 19 years old. What did I do? I volunteered into the Marine Corps at the height of the Tet Offensive. How stupid is that? Knowing what I know now, thank God for my dear beloved mom who put a curse on the Marine Corps and said they're not going to get them. And sure enough, I get over to Fort Holabird, and the sergeant looks up to me and said, "If you lose your classes, how will you know who to shoot?" At the time, I didn't know the right answer, which in my view would have been fine. Give me an M16, point me back to Washington, D.C., 1600 Pennsylvania Avenue, I'll take care of the problem. But the Vietnam War, which wasn't a war, it was a UN peacekeeping effort, and we don't belong to the UN. Story for another day. Just like the Korean War, which is still in existence, by the way, and so is Vietnam. All we have there is a ceasefire in Panmunjom in 1953. These still exist, and as Adam knows, in my view and in our view, the war between the states still exists. There's no evidence of a treaty between the Confederate States of America and the United States government. So the behind the scenes, especially the New York banksters, think this still exists. And that state of war with the Lieber Code and all that is what they're using to try to get around us. And what just happened to Adam, I think, is a direct result of the Lieber Code of 1862. That's what we have to stop, get around and say, not so fast here. We have rights and you know it. What's the problem? You have a sworn oath to be bound by this Constitution and the laws enacted in pursuance thereof. What's hard about that? Anybody out there can answer that question. I'd love to hear it. Back to you, Adam.
Well,
Okay, so we're going to end this video on that note right there. And again, never look just straight forward. Always look around you to be able to protect yourself by any means necessary. Alright, so this is going to be part 1 of the video. Like I said, this is going to be a couple of parts because this is such a long thing. But I figure it's interesting, and if you guys don't, but it's for my records too. Alright, bye y'all.